Okay, it is 1:22 p.m. and the Human Rights first on the agenda is the call to order. Oh, the roll call. I'm sorry. The call to order. The roll call. Yes. Sorry.
Mark McHale, Commissioner.
Victor Montalacci, County Law Department.
Callie Worko, Clerk of Human Rights Commission.
Absent is Commission Chair Natalia Steele, but we have a quorum. There appears to be no public comment. I believe the only order of business is a quick presentation on home rule. This is an interesting legal topic and comes as a follow-up to a question the Commission had received at our public function in Lakewood 2 months ago, where an individual inquired into kind of enforcement mechanisms under the county code. As a disclaimer, this is a purely educational presentation without any legal advice being divulged to the Commission. Such advice would be given in an executive session and would probably involve some valid conflict, like the county would have enforced a provision of the county code and somebody's challenging it on constitutional grounds, or the state of Ohio would be challenging it. This is just to give the commissioners as well as any audience members a refresher on home rule in Ohio. Okay, so home rule. What is it? You know, I've been to many games at the Cavs where being the home team has carried the day, or perhaps a UNC Duke basketball game. You know, the Cameron Crazies carried the day. But under the Ohio Constitution, Section 3, Article 18, says that municipalities shall have authority to exercise all powers of local self-government and to adopt and enforce within their limits such local, police, sanitary, and other similar regulations as are not in conflict with general laws. What does that really mean, though? Well, there's two distinct issues here. One is the power of local self-government, and the other is the police power. So when you have local self-government, that is constitutionally reserved solely to municipalities, such as the city of Cleveland or Cuyahoga County, for example. And any municipal law that is in conflict with the state law that pertains to local self-government, the municipal law will override the state law. On the other hand, police powers, which is generally defined as ordinances that provide for health, safety, and welfare of residents, police powers that municipality exercises, if they are in conflict with the state statute is probably going to override. Local self-government. Oh, can I go back? Can you see if the other slide is going through? Anyways, okay, local self-government. Think administrative issues. Administrative issues within the four corners of the municipality's jurisdiction. Administrative issues that deal with the internal affairs of the municipality. So what to do with municipal property? You know, city owns a rec center. How can they improve it? How can they lease it? Salaries and benefits of city employees, municipal officers. qualifications for council members, recall of elected officials, regulation of civil service, competitive bidding requirements, stuff like that. That's self-government. Police power, on the other hand, regulates conduct. So anytime a city, a state, somebody tells you what to do, exercise of police power. You get a dog, you have to get a dog license. And there's a good chance your city has, under its code, rules related to that. That is exercise of police power. Speed limit, exercise of police power. So in general, criminal offenses, licensing requirement, zoning regulations, residential or commercial zoning. If you remember, municipal zoning would be under local government. So usually when a local statute is in conflict with a state statute, there's a three-part test that is generally applied. So the first, which we kind of went over, is this local ordinance police power or is it self-government? If it's self-government, that's it. If it's police power, then you go on to step two. Is the state law a general law? More on that in a bit, because that's a test within itself. And usually the crux will be on whether the state law is a general law, because it's pretty self-evident when something is police power versus not. So usually the second step is going to be the most important. And then finally, if you have police power exercised by the municipality and you have a state law that deals with the same subject, is the municipal ordinance in conflict with the state statute? If it is in conflict, then it's unconstitutional. A court will probably issue a permanent injunction and declare it unconstitutional. Now, the second step, the general law test, there's a test for determining whether something is a general law, the Canton test. And there's four steps that must all be present. First is that the statute in question is part of a statewide comprehensive legislative enactment. So let's say you're dealing with one issue of landlord-tenant that says something about rent control. Well, the argument would be that that's part of a statewide comprehensive landlord-tenant act. Or you're dealing with one section of single plastic bag use that's part of a comprehension statewide recycling statute. The second step is that that statute in question, the state statute, applies to all parts of the state uniformly. So it can't be a carve-out for corporations, for example, or for individuals defined as people and not corporations. The third step is that it is a police power, because if it's not police, if it's local self-government, then it would be local. And the fourth is that it prescribes a conduct upon citizens generally, which is kind of similar to the second step, but it's split up into 4 steps. And if those 4 steps are met, and then the local municipal ordinance is in conflict, then you're preempted. Then the city, the county, whatever the municipality is preempted. But you cannot be preempted simply by statutory language. So the state assembly cannot include language that says this statute preempts municipalities from enacting similar statutes. Otherwise, that would just be a workaround around this rule. You're only preempt if you prove the factors. So, for example, the Ohio Constitution reserves the right to pass laws regarding an employee's general welfare to the state at Article 2, Section 34. In a Supreme Court case, City of Lima versus the state, City of Lima and the City of Akron had restrictions in their code that city employees had to live within city limits for whatever reason. I mean, I suppose it makes sense, build community, whatever, there's good reasons, but this is in direct conflict with a revised code statute, which says no political subdivision shall require any of its employees as a condition of employment to reside in any specific area of the state. So, in analyzing this, the Supreme Court took a look at the Constitution, said, look, this clearly says safety and general welfare of employees is reserved for the General Assembly. They passed a law in the books that says you can't require individuals to live in certain municipalities as a condition of their employment, and that's exactly what you guys did with your statutes. Therefore, because they're in conflict with the state statute, which is a general law, it's definitely police power because it's telling somebody, an employer, what to do. It applies throughout the whole state, so it meets the Canton test. So this city statutes were found to be unconstitutional. Another example that's come up recently is pay-to-stay ordinances. So under Ohio law, a tenant could be evicted if you're late by 1 day, by $1, and that could lead to maybe you had a bad day, maybe you had a bad month, but business is good, you can make up the rent. But the landlord can use that as an excuse to evict somebody. So many municipalities, including Cleveland, Shaker Heights, Cleveland Heights, have passed pay-to-stay ordinances. So the general idea is that once you're late on your rent, once you trigger something that could get you evicted, even if the landlord files an eviction, a complaint against you, if you make up the money before, during, after proceedings, then you can bring that up as an affirmative defense. And so what that means is if, let's say I'm $500 late on my rent, my landlord wants to evict me, takes me to court. In the meantime, I come up with the $500. Landlord says it's too late. No. I go to court. I tell the judge, look, I have the money. I paid for it. That's a good affirmative defense, and you can't be evicted. Thing is, though, it's very likely that the Ohio Revised Code preempts pay-to-stay ordinances. They just added Section 5321.19 and 5321.20 to the Comprehensive Landlord-Tenant Act, which explicitly preempt municipalities from this type. So far, I don't think it's come up in any courts, which I suppose makes sense because as a practical matter, a landlord is trying to get paid more often than not. So if the tenant can come up with the money, problem solved. But this language right here, this is the explicit preemptive language that Ohio courts have typically found to not be proof that the municipality is preempted. Here it says, the General Assembly further finds and declares that the imposition of rent control and rent stabilization on private residential premises by any political subdivisions is a matter of statewide concern and would be inconsistent with the statewide comprehensive legislative enactment in this chapter. So a court would not take this language into consideration. It would just go through the analysis and determine if the municipal regulation is a police power that is in conflict with the general state law. So yeah, that would be the process. So what would the most likely outcome of any pay-to-stay legislation be? Well, it's clearly a police power because it's telling individuals, landlords, what their obligations are and how they should comport themselves. It's under the second step of the Canton test, the statewide Chapter 5321 is most definitely a general law. The specific sections at issue that preempt rent control are part of the comprehensive landlord-tenant law. It applies uniformly. It sets forth police regulations, again, by regulating landlord-tenant conduct, safety and health in dwellings, and fairness in rental agreements, and it's a rule of general conduct. Everybody at one point or another has probably rented at some point or another, be they a company or an individual. So yeah, it most definitely is a general law. And to the extent that pay-to-stay statutes establish the right of an individual, of a tenant, to pay rent once it's due, once it's overdue, and that be an affirmative defense, that goes beyond what the state has prescribed. So, and this is, there's an article on the Cleveland Metropolitan Bar Association that comes to a similar conclusion, that it's very likely that pay-to-stay would be considered unconstitutional. That particular article mentions other reasons as well, but one of them is the statutory analysis we went through. Another issue that's coming up now is plastic bags. Very similar kind of analysis here. Ohio recently, 2021, Ohio Revised Code sections say basically preempt any single-use plastic bag ban by saying a person may use an auxiliary container for purposes of commerce or otherwise. Auxiliary container includes a bag, a can, cup, soup, or beverage service item, container, keg, bottle, or other packaging. And then there's some other rules that apply that weren't quite relevant. And then person includes an individual, corporation, business trust, estate, trust, partnership, and association. So no person, be that an individual, corporation, trust, may use a bag, can, whatever. A person may use for purposes of commerce or otherwise. Recently, the city of Athens, Ohio, did enact their own ordinance to reduce single-use plastic bags. They say no store owner or vendor shall provide or sell single-use plastic carryout bag to a customer at the checkout stand, cash register, point of sale, or other location for the purposes of transporting food or merchandise from the store after January 1, 2024. State of Ohio sued the city of Athens December 27, 2023, asking for a permanent injunction and that this be declared unconstitutional as an overreach of home rule authority under Section 3, Article 18. So if you do this, if a store chooses to give you a plastic bag at takeout, first offense is a $150 fine, and then a minor misdemeanor citation if you don't pay the fine. And you can appeal that through the court by filing a notice with the city police department. The state says their statute, they're saying that, well, we don't prevent you from creating incentives like tax breaks or something for businesses to become more environmentally friendly. But we do prevent you from regulating businesses and telling them they can't use plastic bags. From the state's complaint, this ordinance is in direct conflict with the state statute, which guarantees all persons in Ohio the right to use single-use plastic bags for commerce. And yeah, citing Canton, they say this is a general law. And then going through the Canton factors, this particular statute preventing municipalities, anybody from banning single-use plastic bags, it's part of the comprehensive code, which is aimed to reduce or recycle, prevent litter and whatnot. It applies throughout the state. It definitely is a police power. It's telling individuals and businesses what they can and can't do, and it's valid throughout the state. So yeah, they're asking for a permanent injunction and to declare a violation of the Ohio Constitution. The city says that's not true. We didn't we didn't extend our home rule authority. They say yes, person, the definition of a person includes an individual, corporation, business, but the ordinance refers to a store or a vendor. It doesn't refer to person as explicitly defined in the state statutes. So that's, you know, that's their argument. And they also say that, you know, this is their authority. Because they are regulating environmentally friendly business practices. This is the overarching scope of this chapter. What's going on? As of June 10th, well, as of early June, the state filed a motion for summary judgment, and the city filed a response against summary judgment, and then they filed responses to their responses. City maintains that the general law is not a general law, that this section fails the Canton test. Specifically, they're saying that protecting the right to generate more trash in the form of single-use plastic bags is not part of the comprehensive scheme to regulate source reduction, recycling, and litter prevention. So they're interpreting this a little bit differently. They also say, well, you know, this definition of person technically excludes LLCs, so it doesn't operate uniformly throughout the state. This isn't really a police statute. It only limits legislative powers of municipalities to exercise police powers. And finally, it's not really a general code of conduct because the word may is a permissive. It doesn't say must. You must use an auxiliary container. You shall. You may. So they're saying, look, this fails the Canton test. Even if the city says, look, this is not our ordinance is not in conflict with the state ordinance because the city ordinance prohibits a store or vendor from distributing single-use bags at the point of sale, but that doesn't mean you can't use the bags. So in their minds, distributing and using are not the same thing. So what does that mean? That means you can show up to the store, you can pull out 3 plastic bags from your pocket, and you can get your groceries that way. And the city would say you can still do that. You can still use plastic bags within commerce, so we're not in direct conflict. We don't really know what the conclusion is yet, but this is currently active in Athens County Common Pleas Court. It'd probably be a good bet that whatever decision is made, the other side will appeal it. And yeah, this particular case has the potential to make it up to the Ohio Supreme Court, and you know, a more definitive defining ruling on home court might be reached. And that is the current state of home rule in Ohio. And those are the 2 main areas where it's, one, it could become an issue is the pay-to-stay legislation, which there's been no action there. And another one, which is the plastic bag ban, which is getting a lot of traction amongst municipalities. That one is currently being litigated. We have a little bit of time.
Yeah, we're pretty flexible. We can do 1:30. Okay, I'll set it for September 17th at 1:30, and then if Natalia has a conflict, we can discuss a new date and time. Yeah, so I had actually made a flyer, and it was approved through our communications and everything. They created it. So my plan is when we go visit the center this week, I'll take some with us. That way we can lay them out. And then if they have anything to add or suggestions that might be helpful, we can take their feedback and kind of go from there.
Any miscellaneous business? Okay, this meeting is